Okay, well, I'm going to try and look at this from a commercial point of view. You're all obviously aware of IP in some form or other in that you've come here. Hopefully I'll be able to help you with realizing what you need to do when, in particular, you're developing a product. What I'm going to look at is the issues that businesses need to look at when they're developing their products, give you some idea of the timeframes and the costs involved, briefly touch on some of the pitfalls that you might encounter if you don't look after the IP, and some of the opportunities that there are if you do look after your IP. A few words on how to avoid infringing other people's rights and what to do if another party approaches you. So, firstly, it's a bit of a jungle out there. There is so much IP with so many different companies, so many different sorts of IP. The question is, how are you going to find your way through this jungle? So there is an awful lot to consider, and what we're trying to do here is to give you an idea of the things that you need to be looking for. One area is contracts. Whenever you're developing a product, you're working with other parties, you're going to have contracts. You need to be careful to review those contracts and make sure that you know who owns what, in order that you don't have problems later on in the later development of the projects. Trademarks, everybody knows about. Protecting your brand, that's important, something to think about. Domain rights, if you're using a website for promoting your product, if you're coming up with new domain names, you need to think about other rights in that area and how it interacts with trademark rights. Patents. Patents is a very complicated subject, but you need to think about whether there is any potential patent rights. The patent box, I'll talk about this a little bit later, but it's a new measure that the government has brought in to try and encourage innovation and development in the UK, which allows companies to reduce their corporation tax on profits that come from innovation made in the UK. Designs, now this is a design show, designs are very important. Designs provide a very inexpensive way of protecting the look and feel of products. Copyright, very important in the context of software. Most products we develop these days have some software aspect, but there's copyright in the 3D designs as well, so there's a design aspect and a copyright aspect. You're going to have all sorts of regulatory requirements you're going to need to look at. Standards for those people who are working in areas which are actually controlled by standards, and then competition law aspects, particularly if you're lucky enough to be dominant in your particular field of activity. So there's an awful lot there. What do we need to do when we're looking at a project, when we're planning it? The important thing is actually to take account of the IP and build action points into your project plan. You need to make sure you've allocated budget for the IP that is going to be as part of that project. So you need to have an idea what IP is going to be in the project, how you're going to spend the money on it. It's not saying you have to spend a lot of money, but you have to make a decision, in my view, about whether you're going to take this seriously, to what extent you're going to either invest in the IP yourself or make suitable investigations as to what IP other people have. The patent box I mentioned earlier, once again I'll come back to that later. For most people, the most important thing is freedom of action. If you're developing a product and you want to get it onto market, you want to be sure that you can get that onto market and you can sell it. In most cases, that is by far the most important thing. You need to be sure that you're not going to infringe rights as soon as something goes onto the market, that you then have to take it off. It's better safe than sorry, and unfortunately most people actually find out about IP when they run into a problem because somebody else has IP and it stops them actually putting their product on the market. I'm going to look at 3 different stages in a project. The first thing is project initiation. When you're actually starting out on a project, you'll have an idea, we want to put this new product on the market, or we've been asked to develop this product. You may be going to be working with other people. You need to think carefully about the interaction with other companies and who is going to own what rights. You need to understand confidentiality terms which will be important in the context, in particular, of patent rights. You need to think about competition law aspects if you are lucky enough to be dominant in your field. And then you can think about the patent box, about what sort of protection in patents you might wish to get in order to be able then to take advantage of the potential savings on corporation tax. These aspects are going to be in most contracts that you will be dealing with when you have contracts with other parties. Part of the problem is that general lawyers do not really understand all of the IP aspects. You may need to get some advice from a specialist IP lawyer, or a patent attorney can maybe help you with those. But it is worth looking at those clauses specifically to see that the clauses are going to give you the rights that you want, whether you are the person commissioning a project or a designer working for somebody else, to make sure that you know who owns what rights and who has what ability to do what. If you're launching a new product and you're coming up with a new name, clearly you need to be able to find a good name to market that under. Making sure that that name is available for you to use is pretty important, because if you start developing the product, you start marketing the product, and then you run into problems on trademarks, that can be a real problem. So it is worth thinking that through at an early stage in the project when you're actually designing the name, the logo, everything else to go with the product. You may want to apply for trademark protection yourself. So if you come across a name, you want to use that for the product, you may want to try and reserve that for your product, in which case apply for the trademark. And then of course, if you're in an area which is regulated by standards, you need to take account of those standards. So these are things right at the beginning of the project. And as I mentioned on the earlier slide, you have to have a budget. So you need to decide how much you're going to put into the IP aspects of your development project. During the project, you're going to have developers working on developing the technical aspects of that product. It is very important that developers keep a record of what they have actually developed. I think this is fairly standard practice in large corporations, but maybe not such standard practice in smaller companies. When I used to work for IBM many years ago, all the inventors had a logbook, just a book that they used to fill in all the details of the innovations that came along, and they used to have that signed off at the end of the day by a colleague within the team. These days you do it electronically. There are systems available for recording what people are doing, but it's just keeping track of who did what when, because ownership, inventorship can become an issue. It's particularly the case if you are working with other parties in developing a product. If you are going to share something with your development partners, and you have developed something or come up with an idea that you then want to share with them, it's a good idea to record that, even if you're under confidentiality agreements, to make sure you did it so there's no confusion later about who came up with the idea. An important aspect is if you do have some innovation where you might want to file a patent application, that patent application has to be secret before you file the application. If it's been made available to the public in any way, that will invalidate the patent application. So even in the context of confidentiality agreements, prudence is necessary when you develop a new idea that you think is going to be really important. I'm not going to go into how you identify inventions here, but a test I have is if you're working in a team with your colleagues and one of you speaks to another colleague and says, I've found a solution to that problem, I'm going to do this. And the colleague says, oh, yeah, it's fine, yeah, no problem. Then it's probably not an invention. But if they say, wow, that's neat, then you probably have an invention. So it's worth thinking about that. If you're in the standards field, if you can, it's worth filing the patent applications before you have to disclose things to the standard bodies, because even though that's within a small group, there are issues in the patent offices now about whether those are public disclosures, even if they are supposed to be allegedly confidential. When you're developing a product and you have a significant design point where you're going to make choices about going one route or another, you might wish to think about doing a patent clearance search. That might help guide you as to which choice to select. Because if one of your choices is already protected by a patent, then you might decide not to go down that route and choose another one. Patent searches can be quite expensive though, so this is something that you would probably need to discuss and decide whether it makes sense. And if you're working with collaboration partners, I recommend that you regularly review any developments which have gone on, once again to establish who did what when, so that you don't have any disputes later. The disputes are expensive and it's much better to get it sorted out early. Now, when you're thinking about the patent box, you need to think about whether a product coming out is protected by a patent for which you've applied and when a patent actually is granted. Because the corporation tax reduction applies to profits made from patented innovation. So if there's a product which is covered by a patent where your company was the inventor or you have significantly developed that product from the initial innovation, then there is the potential to get the reduction in corporation tax from 23% down to 10% on that part of the profits, which can be significant. But you need to know whether the product is actually covered by the patents concerned. So that's something to look at when you're thinking about your patent protection. Before product completion and when things become available to the public, it is well worth then making sure that you haven't got any patent problems, to do clearance searches that might cover your product. Once again, it's worth looking at design protection to see that you've registered any designs which relate to that product before it becomes public, before it goes into the public domain. Design protection in Europe these days can be filed within 12 months of the design becoming public. But patents always have to be filed before that product goes onto the public domain, before it's sold. Once again, at the end of the project, you need to check your contracts to make sure that everything has been done in accordance with the contract with your development partners, because problems can arise. You would need to check that your trademarks and domain names are still clear, particularly if you've thought of them in advance and you haven't actually used them and put them in the public domain. And of course check that the standards and international regulatory requirements are met. Now, I'm not saying you always need to use patent attorneys or solicitors to do this. This is stuff you can do internally as long as you've established procedures and you have the strategy in place to be able to use it, and somebody who's trained up in the basics on these ideas. I said I'd give some ideas of costs. These are very rough estimates, all these costs, because it will depend on the specific circumstances. Trademark clearance searches can be done relatively quickly. 2 weeks, it can be less, say £600. I mean, I won't go over the figures. I should say as well that we have copies of these slides on our stand, which is B105. So if you want to pick those up, you don't need to take notes on the actual figures. But just to give you some ideas of the sorts of costs involved. Patent searches, the problem with a patent clearance search is the invention might be a paperclip or it might be a jet engine. So it's very difficult to say how much it's going to cost to do a clearance search without knowing what the invention is. That's something you'd need to ask. Design clearance searches are very difficult. With a patent is applied for and examined by a patent office. A registered design is a registration process, so there's no examination done. So when you do design clearance, you have to do more analysis to work out whether the design that you would like to use falls within the scope of an existing design. The basic approach I always use is if you have a registered design for a product, say this microphone here which has various bands around the phone, if that is registered, you would compare the design for that microphone to the prior art that existed before, so designs that existed before that, and you would see how it differs, and that would give you a measure of how innovative that design is. Based on how innovative that design is, you would then compare that to the design you want to use and you would make an assessment of whether your design basically follows the design of the lines on the microphone, or whether it's closer to the prior art. So it's a touchy-feely sort of thing, and that's why design clearance searches can be quite expensive. For trademarks, the processing is fairly quick. In the UK, it's about 6 months. For a community trademark, which is what most people will go for these days because that covers the whole of Europe, you're about 9 to 12 months, so it's quite quick. Preparation is very quick as well. That can be done by a trademark attorney or a specialist IP solicitor pretty much immediately and filed the same day. The costs and timeframes in other jurisdictions, so the US, Japan, wherever, will vary quite a lot. Filing an application yourself, given some indications of costs here for filing a registration. Now, where it talks about classes, you file a trademark in particular areas of goods, and these goods are broken down into classes. So you might have one, and I'm not a trademark attorney, I'm a patent attorney, but you will have them for just basically different classes of goods. And if your trademark is going to apply across different classes of goods, you'd need to apply in multiple different classes. Whereas if you are only really interested in protecting the trademark for your specific product, then you would maybe only need to put it in one class. That's why there's a range of costs. I said registered designs are difficult to do clearance searches on. That's probably because they're very easy to file a registered design. It's just a registration process. Having said that, there is some care needed in filing a design, because there are different ways you can protect the design. You can protect the overall look of a design or certain aspects within that design. And you need to think carefully about what you are really trying to protect in the design in order to have powerful design protection. This is something that can be done pretty quickly by a skilled patent or design attorney, and that can be done for you. And once you've got some principles, you can probably, for future designs, do a lot of that work yourself. But that can be done fairly quickly, about a week, because you normally have an exchange of views between the attorney who'll be acting for you and yourself to home in on what is the really important aspects of the design. Now, preparing a patent application, I have prepared and filed patent applications within 1 day, but I don't recommend it. They're very complicated documents. You have to be able to, as an attorney drafting an application, you have to really understand what the invention is. You have to define those claims at the end of a patent which define the novel features of the invention compared to the prior art, and then you have to describe it in sufficient detail that somebody could implement it. For those who don't know that much about patents, patents exist as a deal between an inventor and the state. The state basically says, if you disclose your invention, we will give you up to 20 years monopoly, assuming we think that it's worthy of a monopoly, in return for that disclosure, so that at the end of the 20 years, or when the owner of the patent stops paying the renewal fees, because you have to pay each year for renewals in Europe, that patented idea then goes into the public domain and everybody else can use it. So that's the deal on a patent, and it is quite complicated to draft it. Now, the range of costs, the 3,000 to 10,000, once again depends whether you're looking at a paperclip or a jet engine. There's a huge range of levels of technology that you will have to work on, and the amount of description. So I could describe a paperclip very easily in 2 or 3 pages, even plastic ones. But if you're a jet engine, you can imagine it can be a really thick document, so it's going to cost a lot. And these are just rough ideas. Where to file patent applications? Patents are essentially national rights, which will apply in each individual jurisdiction. You can have a UK patent, you can have a German patent, you can have a French patent, a US patent, so around the world. Some people file patents in lots of countries. They file applications to get patents in many countries. That only makes sense if you can see that you'd get a return on that patent. A patent doesn't give you a right to do anything. It only gives you a right to stop other people doing it. So it gives you a mechanism for arranging a license between people. An example I give is if somebody filed a patent for a bicycle when they first invented the bicycle, assuming that patent was granted, they would be able to stop people for up to 20 years making bicycles. But say somebody got knocked over by a bicycle and thought, these are really dangerous things, I've got an invention, we'll put a bell on a bicycle. That person can file an application for a bell on a bicycle. And if the patent office says, that's actually a good innovative idea, nobody's done that before, the second person can get a patent for the bell on the bicycle. However, he cannot make a bell on a bicycle without getting a license from the guy who has the patent for the bicycle. So even if he gets a patent for that combination, he can't make it without getting a license. Having said that, given that this innovation makes it safe, the guy who was making the bicycles would probably have to start putting bells on his bikes to be able to sell it. So they end up having a cross-license. They talk together, and then each licenses the technology to each other. And for those of you in the electronics industry, that's the way the electronics industry tends to work. So different companies have different patents, and they license them. You've heard about the mobile phone wars at the moment between the various manufacturers of mobile phones asserting their patents against each other. In my personal view, this is a temporary phase, as they are just like boxers sizing up to each other within the ring and trying to decide who has more rights than everybody else. There will come a point where they just end up saying, okay, we'll cross-license each other, and then there will be a deal going on. Somebody may pay money to somebody else, there's somebody else having more patents than the one who's paying the money. But that's really what it's all about. And it's a way of sharing that technology, because let's face it, you can't make a mobile phone without using ideas that somebody else has come up with. I can't remember who it was, but somebody said that whatever I do, there are more bright people who are in other companies than are in my company. So you've really got to bear in mind that everybody is going to come up with innovative ideas. I've given ideas of various costs here. These can vary a lot. The EPO Europe, that is a centralized application which allows you to get individual patents in countries around Europe. I mentioned the International Patent Cooperation Treaty at the bottom. This is a way of slowing down the process. When you file your first patent application, you then have 12 months to file anywhere else in the world, and you can then claim the date that you filed in your first country. So say in the UK you make an innovation, you file a patent application, you have 12 months to think about it and say, which other countries in the world might I want to protect this invention in? With the Patent Cooperation Treaty, that gives you a way of effectively reserving your rights in other countries for up to 30 months from the first date that you filed your UK application. It basically allows you to manage that investment. So you've got more time in your development process to say whether or not you would want to protect anywhere else. Pitfalls, and the guy is going to jump, yeah. The main pitfall is not having an IP strategy. The main pitfall when you're developing a product is not thinking about IP. As I said, you don't necessarily have to spend money, but you at least have to have a strategy. You need to know what you're trying to achieve with your IP. One of those aspects is checking for freedom of action. If you make a large investment in a new product, you get to the point where you're going to launch it, you put it on the supermarket shelves, and then somebody brings a patent action against you or a trademark action against you, that investment may be lost. So checking for the freedom of action is important. Another area which causes problems very often is securing the IP ownership. once again, if you're dealing with other parties, in the case of software, if you have a contract with a software developer, you need to make sure that you know who owns the rights in that software, because otherwise the originator of the software will tend to own it. So if you went to another company, they develop software for you, you need to make sure you've got the freedom of action to do what you need to do with that software. And another pitfall is disclosing information about an invention and then deciding I want to file a patent application, because then it's too late. So you need to make that decision before you disclose the patent information. So the opportunities, it allows you to get that freedom of action. It's not a guarantee, but if you have a strategy, you're more likely to have freedom of action. Potentially you can increase the market share of your company and the status of your company. One of my partners was involved with a US client who bought a UK company for very many millions of pounds. The US company then asked us to go and look at how much innovation they had, what there was that was protectable by patents, and there was an awful lot that was protectable at that stage in the development process, but the company had never protected anything with a patent, and they potentially lost out on the overall value of the company. I'm not saying it will necessarily give you an increased value, but it's definitely something to bear in mind. Potentially it can give recognition for inventors. It's a way of rewarding inventors as well. If you've got people, it can help to motivate inventors, though it depends on how the relationship is with the people actually writing the patent applications. Inventors can find it frustrating if the patent attorney is not used to dealing with people in particular companies. Different companies have different styles, so it's a matter of choosing the right person for the right job. Potentially it can provide a source of revenue. If you have innovation that your competitors want to use, you have the opportunity to license that to other people. So you can license them to use your technology. You can also use it, as I was indicating, as part of a cross-license, as a way of providing a reply to somebody who approaches you with their patent protection. And then there's the potential for corporation tax savings through the patent box. I don't want to go into that in detail here, but as I said before, it's basically that if you have innovation which is developed in the UK based on patents, then there is the potential to reduce your corporation tax in respect to the profits that relate to those products. Now, how to avoid other people's IP rights. As I said at the beginning, it's a bit of a jungle out there. Trying to establish what rights exist is difficult. It can be very expensive. You need to have a strategy with regard to this as well. When you're looking for what you might want to clear, I think an important aspect is to check for innovative aspects in your development. You need to look at the decision points in the development process and look at markets where you're going to be active. So don't necessarily clear everywhere, clear in the countries which are important. One thing you need to bear in mind is a lot of the things you will find in the search are pending applications, not granted patents. You'll look at the claims, what they're claiming as their invention, and you'll think that's amazingly broad. How did they get that? Well, they probably haven't got it. They just said they want it. You always ask for the world and you end up getting a small corner of Coventry, for example. An important thing is, if you find some patents which potentially cover your product, don't ignore it. You definitely don't need to, you shouldn't ignore it. No, you definitely shouldn't ignore that. You need to seek advice from an IP specialist, either a patent attorney or a specialist IP law firm. You've got various courses of action. You can challenge the claim they're making against you. You can say, actually, we don't infringe. You can challenge the rights, the patent rights, the trademark rights, or whatever, and you can try and get those invalidated. If you have your own IP rights, you could have a counterclaim. You could end up with this negotiating situation. You could just decide it's not worth fighting this, we'll give them some money. Or you could redesign your product to get around the problem. Whatever happens, you do need that specialist advice.